Barrera Recycling Company, Los Angeles Reclamation Facility, is a unionized shop where workers are represented by Local 37 of the United Paper Workers International Union. In grievance discussion case 3, safety gloves discharge with just cause, I will take on the role of labor relations manager for Barrera Recycling, in which I will develop a case of support for the legitimate discharge of the employee, Erin McNamara. This will be substantiated with proof that McNamara knowingly violated safety rules repeatedly, was verbally reprimanded, suspended, and finally, justly terminated from her position with Barrera Recycling Company. Erin McNamara, a 20-year veteran of Barrera Recycling and member of Local 37, generally handled bundles of newsprint that were bound tightly with thin plastic straps in the performance of her position. She cut the straps to place the paper into a baling machine and occasionally was required to sort loose paper, tin cans, and glass bottles, many of which arrived broken with jagged and sharp edges. Safety gloves were important, especially for this portion of the job. However, they were bulky and did not allow for workers to easily slide their hands under the paper bundles to cut the straps. For this reason, McNamara and many other workers did not wear safety gloves for this portion of the job to increase efficiency. Though a longtime employee, McNamara had several run-ins with her manager, Rafael Gomez, after transferring to the Los Angeles facility. She incurred 6 or 7 from January to October, the final conversation leading to a 3-day suspension, uncontested by her union. 2 of these reprimands involved not wearing safety gloves. 1 or 2 involved sleeping during safety meetings. 1 was failure to wear a hard hat. Another was improper safety glasses, issued by her previous location. And the final conversation on October 26th related to McNamara reading a magazine while working, leading to the suspension. A month later, Gomez observed McNamara failing to use safety gloves again while sorting due to forgetting them in her vehicle. And even though she got them and continued to work, Gomez fired her, leading to Local 37 to file a grievance protesting her discharge, arguing that there was no just cause. The issues. McNamara's previous disciplinary history from the company is not mentioned in the case history, nor is it necessary to support the basis of this case. Her disciplinary record from January to October 26 is enough to determine that of her 6 or 7 verbal reprimands, all but 1 related to the safety glasses, are the direct response to McNamara deliberately failing to adhere to safety guidelines. 1 more violation led to suspension, and 4 weeks after returning to work, another safety violation was committed, the 7th at minimum violation in less than a year. According to Article 21, Section 5 of the employment contract, written reprimands are stricken only after 1 year of no additional reprimands. None of these reprimands were eligible to be stricken from McNamara's record. McNamara repeatedly disobeyed Gomez and the safety rules by not wearing safety equipment as required, making the most frequent, quote-unquote, cause for immediate discharge, disobedience, number 3. She neglected her duty by eschewing safety rules, sleeping during 1 or 2 safety meetings, and reading a magazine while on duty. These actions breach numbers 6, 10, and 12 in causes for immediate discharge. Perhaps the most contentious issue in this case is number 7 of causes for immediate discharge. It reads, refusal to comply with plant rules, provided that such rules shall be posted in each department where they may be read by all employees, and further, that no changes in present rules or no additional rules shall be made that are inconsistent with this agreement, and further provided that any existing or new rules or changes in rules may be the subject of discussion between the standing committee and the local plant manager, and in case of disagreement, the procedure for other grievances shall apply. According to the case study, only 1 notice titled Reglas de Seguridad pertaining to safety equipment was posted in the lunchroom in Spanish. The translated post read, safety shoes and glasses must be worn at all times. Other safety precautions should be used if directed by the supervisor. McNamara did not speak or read English and had never been in the lunchroom, as she ate lunch in her personal vehicle. If this had been McNamara's first or even second violation of the safety rules related to wearing proper equipment, my position would be in favor of the employee, as she would have been unable to read the posted sign, were she to even have gone into the lunchroom. Barrera is in violation here, as signs are not posted in every department and easily read by all employees. However, after repeatedly making the same safety equipment violation after verbal reprimand, McNamara was therefore willfully and knowingly breaking the rules. The question: as the person responsible for the labor relations at Barrera Recycling Company, articulate a case to support your contention that there was just cause for the discharge of Erin McNamara. A labor relations manager has 3 main roles: building labor relations functions that fit with the goals of the internal environment, acting as a change agent to flex with externalities, and learning to navigate the competing pressures of both. As Barrera's labor relations manager, I need to ensure that I compile data showing why McNamara's employment was justly terminated, and follow a procedure for a grievance case that provides a quote-unquote fair, orderly, and generally efficient method for solving the dispute. Research. The health and safety of employees has been at the crux of labor reform, unionization, and regulation since the 18th century, as mass production just began in the United States. Though defeating the exploitation of the powerless by the powerful was inarguably the basis of the American Constitution, the document was instrumental in protecting the powerful in relationships between the quote-unquote landowner over the sharecropper, the manager over the employee, the husband over the wife, and the white over the black. Years later, the federal government finally took on the responsibility of it, enforcing employee safety laws with the creation of OSHA and NEOSH in 1970. Workers literally worked for centuries for safe workplaces, yet Erin McNamara willfully violated rules made for her health and safety repeatedly. Having a grievance procedure in place is vital to keeping turnover low, improving job tenure, improving human capital, and increasing productivity. Consisting of 3 to 4 steps, the procedure must occur within rigid time limits and is generally controlled by a union, not the employee. Grievance case outcomes for McNamara are exonerated reinstatement, reinstatement with discipline, and upholding termination. Research suggests that unionized workers are very likely to return to work in reinstatement outcomes, while non-union workers will not. The caveat is that in North America, most employees will reject reinstatement in favor of seeking monetary awards during arbitration. Being prepared to oppose monetary awards in arbitration will be of utmost importance. During arbitration, research has found that often arbiters' reference of governing law is generally dependent upon attorney representation and service provider guidance. So knowing who McNamara brings to the table is essential knowledge in arbitration success. Plan of action. The first step after Local 37 files its grievance protesting McNamara's discharge is to compile all the facts involved in the case. McNamara's work history, her disciplinary history, safety history of McNamara's coworkers, affidavit from Manager Gomez relating to each and every disciplinary event for McNamara, Gomez's disciplinary history, both personal discipline and given to his employees, the terms of the employment contract, the applicable rules under the Federal Labor Relations Act, NLRA, Federal Relations Board, NLRB, related case history, and applicable state and federal labor laws. Next, me and my team will meet with the union representatives to hear the grievances in an effort to settle the matter. I will convey Barrera Recycling Company's decision to uphold our decision of termination and give them the set time as per the employee contract to appeal. If an appeal is submitted, another meeting will be scheduled within the contractually required time frame to hear it. My team and I will submit a written response to the appeal within the contractually required time frame. Finally, if there is no resolution, arbitration may be requested by Local 37. An arbiter will be mutually agreed upon from a selection from the American Arbitration Association, and their decision will be final. The union reserves the right to file a complaint with the NLRB if they feel that McNamara's rights given under the NLRA have been violated, leading to a hearing before a NLRB administrative law judge in the absence of a settlement. We feel that at no time were her rights under this act under question and would prepare for any subsequent hearing if needs arise. In conclusion, Erin McNamara was given several more chances than outlined by her employment contract. She repeatedly violated multiple safety rules and committed several actions spelled out as quote-unquote causes for immediate discharge, including disobedience, neglecting her duty, refused to comply with plant rules, sleeping on duty, and reading a magazine while on duty. In my opinion, it is unlikely that appeals will be filed by McNamara's union after receipt of proof of her working behavior and disciplinary history, and her termination will be upheld. Not only did she place herself in danger all too often while on the clock, her lack of adherence to safety guidelines showed a lack of respect for the safety of her coworkers at Barrera Recycling.